did you have any fruitful discussions?
We did, actually. We agreed to a consent judgment on this file.
Okay, what are the terms?
Amount in arrearages is $7,952.45. Court costs of $162, a total redemptive amount of $8,114.45. Mr. Moore has 90 days to pay the redemptive amount to come current on this land contract. Further orders say pay all and any and all outstanding taxes, utilities, insurance as required by the land contract within the 90 days. I've added an extra paragraph that says an escrow analysis will be completed on this account once the account is current, and 10-day appeal period. Mr. Moore has given me permission to sign this consent judgment and submit it to the court for entry. Is that correct, Mr. Moore?
Yes, that is correct. The only thing that I ask is if they can pay the court fees, because I have the email exclusively asking to not go to court and for us to just settle the difference prior to come here, and they denied, because as we said, Manny wanted to make me wait 30 days to receive what they owe me, and now he's saying different. So he could have said that before we went to court.
Mr. Moore, either we have a consent judgment or we don't.
Mr. Moore, here's the thing I guess I'm curious about. You owe $8,000 almost. Were you sitting on the $8,000? Do you have it to pay now?
I tried to prevent this from going to court. At the time of...
But no, listen to me. Did you try to prevent it from coming to court by agreeing to pay the $7,952?
At the time, it was $5,000 something. And yes, I had that cash directly on hand. I was ready to get a check. I offered to bring a cashier's check down, and I cleared the balance with them, and they paid me what they owe me.
What do you mean what they owe you?
Judge, there's this, he didn't have insurance for the first 2 years of this land contract. And so he believes that he is owed insurance payments because he got insurance in September of this year. What I've explained to Mr. Moore is that in order for that to happen, they have to do an escrow analysis on the account. However, he is now 5 months delinquent, and we cannot do a proper escrow analysis on the account. And that's why I added the language in the land contract that as soon as the account is current, they will do an escrow analysis. And if he's entitled to a refund, they will get it to him. He's claiming that there was a conversation that said that the plaintiff said that they wouldn't do it for 30 days. But the issue is that there isn't enough in the escrow account because he's 5 months delinquent. Once he's current, they can do a proper escrow analysis, and they will do that. And that's why I've added the language to the judgment so that he feels confident that they will do that.
All right. And at some point, so if there is money left over in the account,
they're going to give him a check. Yes.
It'll be, at that point, it'll be distributed to you, Mr. Moore. You understand?
Yes. And Jez, I couldn't wait to talk to you because I wanted you to know these things. So I'm not claiming anything, and there's no if. Okay, so they've already admitted to having fault by not auditing my account properly, and yes, they owe me thousands of dollars from the time that we started this to now. Everything I've paid into the escrow. So every month that I've made a payment, regardless of anything that's delinquent that we've had a dispute over, every month I've been unnecessarily paying into the escrow for that.
I would disagree that it was unnecessarily.
Well, wait, just wait.
Right.
I mean,
Thank
here's
you.
the thing. Listen, Mr. Moore, I understand your frustration, but you owe $8,000 in payments on a land contract.
But so, when it was at 5, I tried to stop.
No, listen. So the idea that they're going to give you money out of an account while you still owe them $8,000, I mean, I'm not making a determination at all that you're not entitled to whatever's in the escrow account, but you're not current on the land contract.
Right. When the balance was 5 something, I offered to bring the check down there, and we swap checks. I pay in full, and they pay me. And they said no. They said we're going to make you wait 30 days for your money. I have that email in writing. So I don't claim anything. I don't feel away. I have it in writing. They've admitted fault, and they've told me that they're going to make me wait 30 days purposely to receive my money.
Mr. Moore, Miss Dannon's indicated that they have to do an escrow analysis, and they can't do that until the account is current. So it's not like she's saying, I'm not gonna pay you for 30 days, we're just gonna sit on our hands. She's saying, once you're paid in full, we can do this analysis, and I'm assuming it takes a minute for them to do that, and then
It
they'll
doesn't.
distribute the funds to you.
It doesn't. They can do that the same day. They told me that they are going
All
to
right,
make me
well-
wait 30 days. That's the only
But
problem.
I've
That's why we
cured that
came to court.
before.
Alright,
I've
wait.
already explained that to you 3 times. I've cured that. I put the in language in the judgment that says it'll, as soon as you're current on this account, they'll do the escrow analysis. And I've had the conversation with them as well this morning, Judge. So his his complaint is about something in the past, not now, because I've actually
Right.
cured that.
That brought us here. That's
Well, you
why
guys
we're here.
can't talk, Mr. Moore, you can't talk over her. Go ahead,
Sorry.
ma'am.
Judge, just to be clear, I talked to plaintiff this morning that's what took us so long. So I have cured what he is claiming is what they've said they're going to do. They're not going to do that. They're going to do as I've instructed. And as soon as he is current on this case and with his account, they will do it.
And then they'll distribute funds forthwith?
Yes, Judge.
All right. So, Mr. Moore, I'm writing down what she's telling me. So when you're current, they'll do the escrow analysis and distribute the funds to you forthwith.
Immediately. That's all I asked for. Otherwise,
Well,
we would not be in
forthwith
court
means
now.
like as soon as the work is done. I mean, I don't know what an escrow analysis is. I didn't go to real estate school. I didn't go to mortgage school, right? I don't know if this is something they do in 2 minutes or it's something that takes them a day or two to get done. But as soon as it's done, they're distribute the money to you immediately.
Right, but ma'am, they're saying different this morning than they did in the email. They told me
Well, I
30
know.
days
Well,
that they
now
would make me
they're
wait 30
saying
days.
this.
Okay.
Well, now they're saying this. And she's indicated the money will be distributed to you forthwith.
Okay.
Okay? And I've written that on my paper, that it's to be in the judgment, that the funds are to be distributed like immediately after the escrow analysis is done. So with that being said, Mr. Moore, do you want to enter into this agreement?
Yes, I do. I just hope that they don't use this as a legal loophole to say it took us 30 days to do an analysis when that's not the case. So
Well,
that's
I put it in the judgment.
all right.
It's going to be in the paperwork that she submits. Okay? So I'm giving them attorney fees, but the total amount is $8,114.45. You have 90 days to bring it current and to pay outstanding taxes and utilities. You have a 10-day period to appeal. When current, an escrow analysis will be done and funds will be distributed immediately, forthwith. And that you've given her permission to sign your name on this judgment. Does that all sound accurate, Mr. Moore?
Yes.
And you want me to accept this consent judgment?
Yeah, the last question. I know I'm paying court fees. You said lawyer fees. Who's paying the attorney fees?
It's 162. It's court fees. It's all bundled together.
Okay. The only thing that I was asking, the last thing was that they pay the court fees because I tried to prevent from going to court over these 30 days. That's the only reason why we're here, because they said, no, I'm going to wait 30 days. Now they're saying different. And now I'm paying for court because they said no then, and now they're saying yes. And now I'm the victim of that.
Because you hadn't made a payment on this.
I offered, ma'am. When I had the funds in full, I said, I'll bring it down there right now. They said,
You
no,
said, I'll bring down how much?
the exact amount that was owed at that time. It was like 5 cents. So I said, I'll bring you your check and then you give me mine. They said, no, we're going to make you wait 30 days.
Listen to me, Mr. Moore, if you're telling me $5,000, you said, I'll pay you $5,000 right away. Look, I'm not going to go over this much more, but I'm going to say what are the monthly payments?
$1,273.09.
So you were 4 to 5 months late on payments, and you said, okay, now I'll pay you if we don't go to court. I mean, that's not a defense to the fact that you were months behind on your payments. Look, if you want the consent judgment, I'll enter it. If not, we'll set a trial date. I'm fine with either.
The consent, I'm just too busy for this, so the consent judgment is fine. Like, I'm missing meetings right now. I just had to get this over with. Like,
Okay, well, I can't really just like enter judgments because people want to get it over with. I mean, I need to know.
I
that
literally
this
don't have the
is-
time to,
It
man. So
doesn't
I have
sound
to.
like there's consent is my issue, Ms. Zanin. And I know you two have spent a lot of time on this, but he doesn't agree with any of the terms. He doesn't agree to, a consent judgment means you guys both hash it out and agree to this. And what I
I thought
have
we
is,
had it hashed out, Judge. I wouldn't have come back out because he said he agreed to
yeah,
it.
I agree to everything except the 162. I shouldn't be responsible for it because they initiated court and I tried to prevent court.
Judge, just set it for a hearing. We'll set it for in-person trial.
we'll set it for an in-person trial. And we can come in on December 12th.
Mr. Moore, you realize that this is going to add the December's payment as well, too, right?
And like I can't even be available that day. So just do the consent thing. I fully agree with it.
No,
Like I can't physically be there, man.
Listen,
I can't physically be there is my point. I'm
all
so
right,
I'm gonna
Mr.
just please do the
Morales,
consent.
how about you? Okay, no, I'm not entering a consent under those conditions. You don't consent.
I'll pay the 162 because I'm gonna get more trouble if I don't. So it's worth paying. I don't want to pay it, but I'll pay it. But y'all got my arms tied behind my back because I can't physically be there that day. I know I can't. So please answer the consent. I'll pay the 162, even though I don't want to. I agree to it. Let's do it.
All right, submit the judgment.
Thank you, Judge.
All right. Mr. Fink, you're back with us.